person performs a sexual act on another person of the same gender or allows a person of the same gender to perform a sexual act on him or her. 2, a person who commits the offense of homosexuality is liable on conviction to imprisonment for life. 3, a person who attempts to perform a sexual act in circumstances referred to in subsection 1 commits an offense and is liable on conviction to imprisonment.
Honorable members, listen.
To imprisonment for a period not exceeding 7 years. Four, notwithstanding subsection 2, a person charged with an offense under this section may, in mitigation of sentence, submit evidence from a medical practitioner appointed by the Medical and Dental Practitioners Council, proving that the accused person was
switch on the mic.
Let me repeat 4. Notwithstanding subsection 2, a person charged with an offense under this section may, in mitigation of sentence, submit evidence from a medical practitioner appointed by the Medical and Dental Practitioners Council, proving that the accused person was, at the time of the commission of the offense, suffering genetic abnormalities which may have contributed to the acts that constitute the offense of homosexuality. 5. For purposes of subsection 3, a person shall be deemed to attempt to commit an offense when the person intending to commit an offense begins to put his or her intention into execution by means adapted to its fulfillment and manifests his or her intention by some overt act, but does not fulfill his or her intention to such an extent as to commit the offense. Justification: to remove a conflict between the definition of the words homosexuality and sexual act in clause 1 and the prescription of the offense of homosexuality in clause 2 of the bill, since they each prescribed different elements, making the offense of homosexuality vague, thereby contravening the principle of legality prescribed in Article 28(12) of the Constitution. To limit the offense of homosexuality to the penetration, however slight, of a person's anus by another person's sexual organ, of a person's anus, sexual organ, or mouth by a sexual organ of another person of the same gender, or of a person's anus, sexual organ, or mouth by an object or sex contraption by a person of the same gender. As guided by court in the case of Kasha Jacqueline, David Katoch Sule, and Onzeima.
Honorable members, please listen to the chair.
And Onzeima Patience versus Rolling Stone Limited and Gilles Mohammed, High Court Miscellaneous Cause number 163 of 2010, to limit the offense of homosexuality to the actual performance of a sexual act between persons, as required in Section 37 of the Interpretation Act, to prescribe the maximum penalty that can be imposed by court in order to recognize and maintain court discretion in sentencing, to expand the provision to include an attempt to commit the offense of homosexuality, to move provisions relating to sexual orientation to clause 14 on promotion of the offense of homosexuality, to increase the penalty for the offense in the case of homosexuality from 10 years as proposed in the bill to 20 years, and for the attempts from 2 years to 7 years in tandem with sentences imposed for similar sexual offenses. The proposal to allow a person charged with an offense under the section to mitigate the sentence by adducing evidence of genetic disorders is to recognize evidence from Uganda Medical Association, which explained that a small number of people may have homosexual tendencies because of abnormalities in their genes or biological disorders, to delete provisions that criminalize a person who has not committed an offense of homosexuality.
Thank you, Chair. Yes.
Madam Chair, I want to thank the Chair, but why is she Why, Madam, I want the chairperson to assist me to understand. Why did you remove the people of the same sex and brought gender? Because the moment you bring gender, a man will come and say, I'm transgender and whatever. Yeah, so to avoid this, it should be of the same what? Sex. And the second one, so Madam Chair.
Chair, are you hearing what?
Yes. Madam Chair, the second item, offenses. Yes, first of all, we're moving in line with section 145 of the Penal Code. Where anybody who acts unnaturally must have life what? Imprisonment. Madam, life, okay, whatever. Madam Chair, the moment we allow a space in that law, people will practice it. One, you are saying if you are about to attempt, how do you measure about to attempt? If you are saying you are caught, you are about to practice it, how do you know it? Anybody caught with a stolen item is a thief. Anybody who aids somebody to steal is a thief. And the charges of a thief will also apply to the one who aids or who is aiding. So, Madam Chair, I want to implore the chair to agree that the penalties should be the same. For those who are trying to procure, for those who are about to practice, so that they all go for life imprisonment. This will deter this act we are fighting.
Thank you. Thank you. Can I hear from Attorney General?
Thank you very much, Madam Chair.
You could answer together. It's similar. Thank you, Right Honourable Speaker. Right Honourable Speaker, I need to be guided, Right Honourable Speaker, because the penalties, because when we read the penal code, if we are to quote 145, what Honourable Fox was talking about, the penalty is death. But also when we refer to the Bible, Leviticus 20:13, what my colleague there quoted, the Bible talks about death. So how do we now degrade the sentence? We yet in the penal code it talks about death, the Bible is talking about death, but we are now degrading it to years or to life imprisonment. I need to be helped. How do we harmonize?
Yes, there is an amendment on the sex instead of gender. That one, take note. Yes.
Thank you, Right Honourable Speaker.
Honourable members, listen.
In response to Honourable Nadala Mafabi, the punishment for an attempt cannot be the same as the punishment for the act itself. That's why the proviso is that the attempt is 7 years and the act is life. That's how it is even in the penal code, where they provide for unnatural offences.
Is obsolete. We are saying the penal code is obsolete. No.
Madam Chair, in criminal law, even if we are saying that the penal code needs to be beefed up, an attempt is very different from the actual act.
Honourable members.
Madam Speaker, in criminal law generally, an attempt is very different from the actual act, because I'm a lawyer who worked in Attorney Generals for 25 and a half years, so I know what I'm talking about. Now, no, I'm not quarreling. An attempt is very different. Just look at it practically. Somebody, even if it's, say, rape, somebody comes into the room and tries to get hold of you and you fight him. So he hasn't penetrated you. Now, for someone who actually ends up chewing you, sorry.
Honourable members. Honourable members. Honourable members. The person who does the attempt is also a danger to society. And if we are saying we want a deterrent measure, we should give a sanction that is prohibitive. 7 years, I will go for 7 years and come out.
Honorable Asumani. Can we hear from Asuman?
Right Honourable Chair, I am in agreement. I'm in agreement with the proposal by the committee, and especially the justification of consistency and clarity, and the need to address the principle of legality, which was disturbing my brother, the homosexualist. Chair, let me clarify this. In the committee, we learned 2 terms. There's a difference between a homosexual and a homosexualist. Honorable Fox is a homosexualist. A homosexualist is the one who protects, promotes, defends. And we agreed that he is not offended to call him a homosexualist. So his concern was the principle of legality. And when you look at the proposal by the committee, it addresses that principle, and indeed
Right Honorable Chair, you have always advised us to speak with evidence. The Honorable Asumani Basalirwa
has described the Honorable Fox Odoi as a homosexualist and not a homosexual. Does he have evidence that he's not? Is he in order, therefore?
Information.
Facts speak for themselves. No, by promoting, facts speak for them. Honorable Segona, facts speak for themselves. Yes, can you proceed? By the way, we have so many clauses, we have to move.
So, Chair, I want to invite the August House to be persuaded by the amendments proposed by the committee, because they are consistent and they clarify matters of the law in relation to sexual offenses. And it is not true, Chair, that the penal code proposes death. No, the penal code proposes life imprisonment.
Yes.
And we want to be consistent. However,
what about the aspect of sex vis-a-vis gender?
Yes, the aspect of sex vis-a-vis gender. Chair, we have not looked at clause 1, but clause 1 has interpreted...
Sex means gender.
Clause 1 has interpreted what gender means. Maybe when we get there, the concerns of the members will be addressed. But in terms of, in fact, gender, as explained by the committee, is broader than even the sex we are talking about. So the committee, maybe the chair, because you guided that we first move away from the interpretation clause. If we went there, people would be able to understand the definition of gender. It carries the concerns. It is not the dictionary definition of gender that people understand.
Honorable Katuntu.
Information.
Thank you very much, right, Honorable Chairperson. Colleagues, I would like to implore upon you to listen to the committee. We tried as much as possible not to offend provisions of the Constitution. As much as possible. Because the enemies of this bill, we know where they are going after here. And that has nothing to do with the Honorable Fox. But the enemies of the bill, The promoters of homosexuality, we know their path. And their path is a court of law. So, we did our best, Madam Chairperson.
Order.
Honorable members, you have heard what the committee has said. The private member is in agreement with the committee.
I have a
amendment. And in
Madam Chair,
Madam Chair,
on the issue of sex.
Nathan, please. Colleagues, and please listen. We must, as much as possible, trade within the Constitution, within the law. We have, as you'll see later, we have defined sex, we have defined gender, we have defined sexual orientation, such that there is no gray area at all. And we have our decision, our opinion was formed by the recent case in Kenya. For those of you who have had time to read it. So, if you have not read the definitions, and it's quite unfortunate, but maybe the chairperson, when you're explaining, we have not reached there, you need to explain to the colleagues that we have already defined all of them. When you go to attempts, including murder, chairperson, in the penal code, there is the case of attempted murder. If you have an attempt, if you're attempting to commit a crime, you can't be criminal at the same level with somebody who has gone ahead and actually committed the crime. So the sentence should differ. What we should be debating, for us we suggested 7 years. For those attempting. If you think we need to raise it, that is okay, we can debate that. But for us, we proposed 7 years.
Madam Chair, before we move to Madam Chair,
Honorable Bariomusi.
Madam Chair, before we move to
Honorable Bariomusi.
You're confused.
Thank you very much, Madam Chair. I was raising on another issue, not the sentence, because from what the chair reported, the committee, I think, interfaced with the medical doctors. And the doctors seems to have given a position that there is genetic predisposition, but we are also doctors. Some of us do not agree, and we have looked at the body of evidence. So I want to know from the committee the position which was given, because, Madam Chair, last time...
Are you on the amendment of
yes,
clause
because...
I mean clause 2. Are you on amendment? We are now talking about the years.
Okay, because it runs through what the chair raised. But we can dispose of the issue of the sentence, then you give me chance to raise my point, because it runs through the process.
The years.
Thank you, Madam Chair. Madam Chair, I would want to propose an amendment from 7 to 10. Those who attempt from 7 to 10.
Attorney General.
Ten years is okay.
Thank you. The amendment of 10 years for attempted.
Madam
I
Chair.
put a question that clause 2 be amended as proposed by the committee and amended by the Attorney General with the 10 years on attempted. Those in favor say and the contrary nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 3.
Clause 3.
Right Honorable. Hello. Right Honorable.
Clause 3, aggravated homosexuality. For clause 3, there's
Right Honorable.
There's substituted the following.
Honorable members, listen to the chair.
Clause 3, aggravated homosexuality. For clause 3, there is substituted the following. 3. Aggravated homosexuality. 1. A person who commits the offense of homosexuality in any of the circumstances specified in subsection 2 commits the offense of aggravated homosexuality and is liable on conviction to suffer death. 2. The circumstances referred to in subsection 1 are where A. The person against whom the offense is committed is a child. B. The offender is a parent, guardian, or relative of the person against whom the offense is committed. C. The person against whom the offense is committed contracts a terminal illness as a result of the sexual act. D. The offender is a serial offender. E. The offender is a person in authority over the person against whom the offense is committed. F. The person against whom the offense is committed is a person with disability or suffers a disability as a result of the sexual act. G. The person against whom the offense is committed is a person with mental illness or suffers a mental illness as a result of the sexual act. H. The person against whom the offense is committed is of advanced age. I. The offense was committed against a person by means of threats, force, fear of bodily harm, duress, undue influence, through misrepresentation as to the nature of the act, or intimidation of any kind. J. The person against whom the offense is committed was, at the time the offense was committed, unconscious or in an altered state of consciousness due to the influence of medicine, drugs, alcohol, or any other substance that impaired his or her judgment. 3. A person who attempts to perform a sexual act in circumstances referred to in subsection 1 commits an offense and is liable on conviction to imprisonment for a period not exceeding 14 years. 4. A person charged with an offense under this section may, in mitigation of sentence, submit evidence from a medical practitioner appointed by the Medical and Dental Practitioners Council, proving that the accused person was, at the time of the commission of the offense, suffering genetic abnormalities which might have contributed to the acts that constitute the offense of homosexuality. 5. For purposes of subsection 4, a person shall be deemed to attempt to commit an offense when the person intending to commit an offense begins to put his or her intention into execution by means adapted to its fulfillment and manifests his or her intention by some overt act, but does not fulfill his or her intention to such an extent as to commit the offense. Justification: to harmonize the punishment for aggravated homosexuality with the punishment prescribed for similar offenses under the Penal Code. To harmonize the penalty prescribed in this clause with Section 129 of the Penal Code Act relating to defilement. To harmonize the punishment for the offense of homosexuality and aggravated homosexuality. To expand the provision to include other matters that aggravate the offense of homosexuality. To expand the provision to include other categories of infection and incurable diseases that might arise from the sexual act. The proposal to allow a person charged with an offense under the section to mitigate the sentence by adducing evidence of genetic disorders is to recognize evidence from Uganda Medical Association, which explained that a small number of people may have homosexual tendencies because of abnormalities in their genes or biological disorders.
Thank you, Asman. Asman.
Chair, I have no objection to the proposal by the committee.
Attorney General.
I have no objection. I concede.
I put a question that clause 3 be amended as proposed. Those in favor say on the contrary nay.
Information.
The ayes have it.
Clause 3 as amended.
I put a question that clause 3 as amended stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 4.
Clause 4. Clause 4. This
Clause
bill,
4.
This bill
Attempt
has been
to commit
harmonized.
homosexuality. Delete clause 4. Justification. The provisions of clause 4 have been inserted in clauses 2 and 3 of the bill.
Madam
Same
Chair,
with you.
thank you very much. I will request that we recommit parts of clause 3 because I disagree with 4. The one that says someone can plead that this is genetic abnormalities. Even thieves will say this is genetic problems. So my request is that after the bill we recommit this.
But I thought you're a member of the committee. What happened in the committee?
Madam Chair, at a committee stage I am not stopped from making a proposal. I am only stopped from debating during the second.
We'll recommit it. Let's go ahead. 4. Clause 4.
Clause 4. Attempt to commit homosexuality. Delete clause 4. Justification. The provisions of clause 4 have been inserted in clauses 2 and 3 of the bill.
Yes, Your Court. Let me first hear from Asuman. Clause 4.
Chair, no objection.
Clause 4.
Thank you, Madam Chair. Madam Chair, I think we should not delete clause number 4 because clause number 4 is talking about even the intention. Because if you have an intention to commit something which is not right.
Intention has been covered in clause 2 and 3. It has been covered.
Redundant. If it has been covered up there, then we.
Attorney General.
I submit.
Attorney
I follow
General. Attorney General.
I concede to the proposal.
I put a question that clause 4 be deleted as proposed. Those in favor say on the contrary, nay. The ayes have it.
New clause.
New clause.
Insertion of new clause immediately after 4. The bill is amended by inserting immediately after clause 4 the following new clause. Punishment for child homosexuality. A child who is convicted of an offense under section 2 or 3 of this act shall, instead of the punishments prescribed under the relevant section, be liable on conviction to imprisonment for a period not exceeding 3 years. Justification: to limit the punishment that can be imposed on a child homosexual to 3 years as required in section 94(1)(g) of the Children Act, Cap 120.
Honorable members, we are talking about a child, not an adult. And we have the Children's Act. Asumani?
No, Chair.
By the way, a child does not go to Luzira. They go to remand homes.
Yes. Chair, maybe just to give more clarification, it is the reason why we needed this bill as a one-stop center. Because you see, you are now looking at the Children's Act, you are now looking at the Penal Code Act. And the justification being given is that where a piece of legislation elsewhere is clear on a matter, like this one, you are not going to deviate from it. So when we are talking about children, in any legislation we make, our first point of reference is the Children's Act. So this is just being consistent with the Children's Act, and the 3 years must be looked at from that context that we are dealing with the children.
Yes.
Madam Chair, my concern here is about the mitigation, because if we allow these very people to go and mix up in prison, can't we suggest and recommend that
That
we
is
open
in
up?
that is in another clause. You're moving faster than the House. Yes. Enos.
Thank you so much, Madam Chair. I know what I'm going to suggest is a bit inconsistent with other laws, but I wanted us to redefine a child to be 22 years because the average age. Wait! Why don't you listen? The average age, Madam Chair, the average age.
Now, as a legislator,
wait a minute, Madam.
I am surprised you don't know what age a kid is.
That's why I put a disclaimer. Why don't you allow me finish my argument? Why don't you allow me finish the argument?
Chair.
Attorney General.
Madam Chair.
Thank you, Madam Speaker. Can we have some order?
Honorable Enos,
for purposes of
you
clarity.
sought to uphold the Constitution, now you want to rape the Constitution.
Right, Honorable Speaker, for purposes of clarity.
Honorable members, listen.
For purposes of clarity, the age of majority is 18 and above.
Years.
Now, for us to raise it, a child to 22, would mean that we are amending the Constitution.
Unconstitutional.
And that would mean that this bill we are trying to pass today would tomorrow be declared unconstitutional on the basis of that.
Today you have guided the properly.
Honorable Attorney General, are you in agreement with the amendment?
Yes, Right Honorable Speaker, I agree with you.
Chair, my concern is a child of 14 years is different from a child of 17 years. So if we could have the punishment differently, that could be better.
A child is a child. Yes? Honorable Guang. Yes?
Thank you so much, Madam Chair. The information that's moving around, which is very clear, most of our children who are being lured into homosexuality is all about money. And you know, these children...
Give me the amendment. What is the amendment?
The amendment I'm talking about is the period, if you say only 3 years, these people who are practicing homosexuality may buy off those kind of thing to a child. And the child can be attempted to go in for. Therefore, I would think we should increase the number of years.
How is it related to the amendment?
It is about the child who will be involved in homosexuality. They propose should be in prison for 3 years. That's the proposal they have put. Yes. But I'm saying that time, that period of 3 years is not enough because they can't even go further to convince that child to accept anything of that kind. Then within the 3 years will not be enough. We are proposed it should be increased to 10 years.
Madam Chair, the standard of 3 years
Honorable members
is provided for in other laws.
Yes.
Issues being raised by honorable
members, I want to refer you to the Children's Act.
Yes.
The law is in conformity with the other laws. I put a question that the proposed new clause stands part of the bill. Those in favor say on the contrary, nay. Let's have it.
Clause 5.
You people, we are not moving.
Clause 5, protection, assistance and payment of compensation to victims of homosexuality. Clause 5 of the bill is amended by A, deleting subclause 1, B, substituting for subclause 2 the following. 2, a person involved in the investigation, prosecution or trial of offences under this act shall assist the victim of the offence present his or her views and concerns at the appropriate stages of the criminal proceedings. Justification, subclause 1 is deleted since it has potential to be abused by victims to commit crimes against accused persons before the acts complained of are investigated by the police and the accused person prosecuted. It will encourage mob justice and it takes away the accused presumption of innocence prescribed in Article 28(3)(a) of the Constitution. For clarity and better drafting.
Asman?
I concur, Right Honourable Chair.
AG.
I concede.
I put it.
It is under this clause which talks of protection that I want to re-echo the words of the President when he was discussing homosexuality. He was drawing a line.
What amendment are you making?
Whether it's a nurtured activity or it's an activity due to nature. So we want...
Give me the amendment.
Yeah. Hey. Right Honourable Speaker, the amendment I'm bringing on board is to take care of those people nurturing children into this activity. And to also
It does not fall under here. Give me the amendment that you want to make.
I'm looking at protection.
What about protection?
Protecting the children.
Honorable members, I put a question that clause 5 be amended as proposed. Those in favor say on the contrary, nay. Nice have it.
Clause 5 as amended.
I put a question that clause 5 as amended stands part of the bill. Those in favor say on the contrary, nay. Nice have it.
Clause 6.
Clause 6.
For clause 6, consent of a victim of homosexuality. For clause 6, they substituted the following. Consent to sexual act is no defense. The consent of a person to commit a sexual act shall not constitute a defense to a charge under this act. Justification: to expand the provision to declare as irrelevant the consent of any person to the performance of a sexual act that constitutes an offense under this act, rather than limiting the provisions to victims of offenses as proposed under the bill.
Hasman?
Clarification.
Yes.
Madam Chair.
Next time you don't speak.
I want to seek clarification from the chair whether when they were considering the issue of consent, they looked at a consent that is gotten at marriage. We have had cases where married couples in church procure consent to hold out on heterosexual relationship. When they enter into that marriage relationship, they turn around and go into homosexual activities, subdue the person, and now you are saying consent. Consent, what consent are you talking about? Is it this consent that was procured at marriage, or which consent are you talking about?
Honorable Chair.
Can I help?
In the circumstances, because the victim will be innocent.
Can I help?
Chair, rules.
Honourable member, this bill is about same-sex relationship. It's not about heterosexuals.
And it's not about marriage.
And it's not about marriage. And under Article 31, marriage between people of the same sex is prohibited. So the issue of marriage of people of the same sex does not arise because it is unconstitutional.
We are talking about heterosexuals, Madam Chair.
This bill is not about heterosexuals.
Yeah, Honorable Chair.
Honorable AG.
Honorable Chair.
Attorney General. Honorable members. Honorable members.
Thank you, Madam Chairperson.
Give me the amendment.
Yes, Madam Chairperson, the amendment I wanted to make relates to Tinka Simile's concern.
No, that one has been solved. That has been corrected.
Madam Chairperson, it is not. The Tinka Simile's concern was people who go into a marriage as heterosexuals. Thereafter conducting a marriage, they turn into doing homosexuality. When they are in a marriage and they are heterosexuals.
The unnatural acts have been handled in clause 2. Those are natural acts.
Yeah, Honorable Chair.
Honorable members. Honorable members.
Honorable Chair, on consent.
Honorable members, I know how much you feel for this,
Honorable Chair, on
but we
consent.
must move. Honorable members.
Madam Chair. Madam Chair.
Madam Chair.
Honorable, there is nothing to be corrected here, Medi.
No, I'm talking about consent. Thank you, Madam Chair. Maybe honorable members must arise to the fact that because this may be pleaded as a defense that they were consenting adults. That is why we are clearly legislating that consent shall not be a defense.
Yes.
That is what they are saying under this act. Therefore, you shall not plead that X and Y consented to perform this act.
I put a question that clause 6 be amended as proposed. Those in favor sign the contrary, nay. The ayes have it.
Clause 6 as amended.
I put a question that clause 6 as amended stands part of the bill. Those in favor sign the contrary, nay. The ayes have it.
Clause 7.
Clause 7. Clause 7. Clause 7. Clause 7. Sit.
Clause 7, confidentiality. In clause 7,
honorable members, listen, Esther.
Clause 7, confidentiality. In clause 7, delete subclauses 1 and 2. Justification, clause 7, 1 and 2 are redundant since clause 7, 1 is already a practice of court, while 7, 2 is provided for under Article 28(2) of the Constitution, which allows a court or tribunal to exclude the press or the public from all or any proceedings before it for reasons.
Switch on.
For reasons of morality, public order, or national security, as may be in a free and democratic society.
Asman?
No objection.
Attorney General?
No objection.
I put a question that clause 7 be amended as proposed. Those in favor say and to contrary nay. The ayes have
Clause
it.
7 as amended.
Madam Chair, clause 7 deals with our children. And the penalty provided on 7, Madam Chair, is not fair. Because this is the only way.
What penalty do you recommend?
Madam Chair, they propose 10 years only. In clause 7, they are proposing only 10 years for somebody who recruits our children into homosexuality. So let it be life imprisonment for whoever recruits our children, for whoever gets involved in making sure that our children are involved into this.
Now, Chair, I think for information purposes, that's not what clause 7 is saying.
Honorable Patrick, clause 7 is on confidentiality and aiding and abetting is on clause 8. So you're legislating ahead. Honorable members, I put a question that clause 7 be amended as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
New clause.
New clause. Sarah, sit. You sit.
Insertion of new clauses immediately before clause 8. The bill is amended by inserting before clause 8 the following. Child grooming. A person who A. recruits, transports, transfers, harbors, or receives a child for the purpose of engaging the child in homosexuality or any other conduct prohibited under this act. B. displays, distributes, or supplies to a child any material demonstrating, depicting, or illustrating a sexual act between persons of the same gender or any other conduct that is prohibited under this act. C. shows or avails a child in a picture video or film showing depicting or illustrating a sexual act between persons of the same gender or any other conduct that is prohibited under this act, or D, in the presence of a child, performs a sexual act with a person of the same gender or causes another person to engage in a sexual act with a person of the same gender, commits an offense and is liable on conviction to imprisonment for a period not exceeding 10 years. 2, the consent of a child of that child's parent, guardian, person in authority, or any other person with parental responsibility over the child to the acts prescribed in subsection 1 shall not be a defense to a charge under this act. Justification: to prohibit acts that expose children to acts of homosexuality.
Cecilia.
Chair, I have a concern on the punishment of 10 years. We have seen some videos moving around of young children of 4 years, 3 years being inducted or forced into the act of homosexuality. Now, in that situation, Chair, a child is completely disoriented as far as sexuality is concerned. Now, how can you prescribe only 10 years? Such people really, even if we are trying to be merciful, should be life. Because your child is damaged. Your child is damaged for life, disoriented for life. These people need punishment for life. They must in prison for life. Thank you.
Chair.
Attorney General. We have an amendment from Imat Cecilia.
The proposal of the committee is 10 years. Mama Cecilia proposes life. If the argument is about the length of imprisonment, we could find a middle ground and propose 15 to 20.
Attorney General,
yes.
Attorney General, Attorney General, imagine it is your own child. Imagine it is your own child, Attorney General.
Yes, amendment.
Thank you, Madam.
Thank you, Madam Chair. Madam Chair. Madam Chair.
Can you look?
Where somebody has got your child, imagine the child is 2 years, is 3 years. Even life imprisonment is not adequate because this person is going to go into the prisons and continue living his life, maybe even continuing with homosexuality in the prisons. These people should be castrated. Yes. The amendment I'm proposing is that the person should be castrated, Madam Speaker.
Honorable Elijah.
Yeah.
Elijah.
Yeah, thank you, Madam Chair. Madam Chair.
Elijah.
Madam Chair.
Madam Chair, I want to concur.
Give me the yes.
Yes, I want to concur with Madam Cecilia Ogwal, because the damage here caused is for life. So I think the basis we said the sentence to life imprisonment, because the damage to this child is for life. So let the sentence also be for life. Thank you.
Honorable members, the issue is you're saying the 10 years are few. How many years?
Life.
Madam Chair, I would urge my colleagues generally, one, because I've heard these sentiments coming out, supposing it is your child. As legislators, we do not want to
let's
go
not put personal feelings
on
in
record
this.
because we would be losing objectivity. That's point number one. Number two, in our legislation, let's keep remembering the two principles of legality
and proportionality. Because whatever we are saying here, you see, it is a point of law. It is a point of law. And I signed this report. I am conscious I have a duty to protect it. Legality, proportionality, and emotions out of this. Thank
So
you.
how many years are you? Are you in agreement with the committee?
Yes, I'm in agreement.
Thank you, Chair.
Dr. Bedi.
Thank you. Thank you. Thank you, Right Honourable.
Dr. Bedi.
Thank you, Right
Madam Chair.
Honourable Chair. Right Honourable Chair. Right Honourable Chair, I'm rehabilitating a child who was recruited in primary 7. I want us to amend that the offense comes from 10 to 20 years. To 20 years.
What is different?
Yes, I understand.
This is different on this clause. That's different.
Right Honourable Chair, it is important that we find...
Can we hear
Madam
from
Chair.
the Attorney General?
Madam Chair, I wanted to raise
Because
something very key.
we are talking about years. Can we hear from Attorney General?
Colleagues, in light of the proportionality that Honorable Segona has urged, I would want us to agree that 20 years would suffice.
Can I have Lob?
Thank you, Right Honourable Chair. The disservice the Honourable Land Attorney General and my other land friends have done to this House is not to explain under sentencing guidelines that actual life can be 3 years. And I'm telling you what actually is. That actually when you prescribe 15 to 20 is more appropriate than generally saying life.
Yes.
The land attorney can explain actually what it means. So don't simply say life. Legally, life can mean actually 5 years, depending on how the presiding officer construes the matter being considered. So please, you should have been helpful to the House to say life is not actually life. The chair can also guide, right, Honourable Speaker. I thought that should really be well understood.
Chair.
Thank you, Right Honourable Speaker and Honourable Members. Honourable Members, prescription of offences must be based on time or the penalty ultimately. Different countries have defined life imprisonment differently, and this is from practice. Wherefore, if you want to say 30 years, say it. If you want to say 40 years, say it. Otherwise, the mere saying that the punishment should be imprisonment for life does not exactly imply that the judicial officer shall describe life in case of the person to mean all time behind bars. And that is through practice and what is there. Therefore, it's my humble view, Right Honourable Speaker, that we call upon the proposer to clearly state whether it is 25 or 30 or 10 or 20, and we move.
Order, Right Honourable Speaker. Order.
Segona.
Can I say something? Right Honourable Speaker, as Right Honourable Chair, Madam Chair, I think that one has been sorted by
How
the
many?
latest jurisprudence.
Yes.
In the case of Tigo, the Supreme Court has stated that when
Honourable
the legislation,
members, listen.
when the legislation says life imprisonment, they mean your natural life,
Your natural life.
your entire life.
Yes.
So I think that one ceases to be contentious.
Yes.
I am in agreement with the committee. I signed the report.
Can I have Fox? Where is Fox? Honorable Fox.
Right, Honorable Chair.
Honorable members. Honorable Fox.
Right, Honorable Chair. Just permit me 2 minutes.
Number one, when it comes to the protection of children, we all should speak with one voice. The protection of minors, we all must speak with one voice. And that position applies to heterosexual sex as it applies to homosexual sex. Children have no space in the sex world. And I will encourage all of you to protect our children.
How many years?
That said, Right Honorable Chair, I am a member of the committee, and the 10 years is sufficient.
Right, Honorable Speaker.
Madam Speaker, thank you very much.
Madam Chair.
Thank you very much, Madam Speaker. Madam Speaker, the problem we are dealing with, if members can listen, you see, Madam Chair, A speaks about recruiting children, transporting them, blah, blah, for purposes of engaging them. In English, it means etc. Madam Chair, while B and C and D are about either someone committing homosexuality in the presence of a child or distributes material. These offenses cannot attract the same sentence. Someone trafficking a child for homosexuality and someone showing a film. I therefore want to propose, Madam Speaker, that in case of A, life imprisonment, in case of B, C, and D, 20 years.
Honorable members, I put a question that the proposed new clause stands part of the bill with amendment of 20 years as proposed by Honorable Semuju and Attorney General. Those in favor say on the contrary, aye? The ayes have it.
Clause 8.
Honorable members, so why are you making noise? If you want to make an amendment, your private members, you will make an amendment. This is the first law you're making. And you can make amendment anytime you want. Let's be orderly and honorable enough.
Clause 8.
Clause 8.
Thank you so much, Chair. Honorable Semuju's amendment had two effects, and your bundling, I don't know whether it has separated part of the clause, because
it did as proposed by Honorable Semuju. He mentioned it. Then so I am going by what he said.
Then, Chair, I prefer recommit on a part of separating it.
No, it is already separated. I took it as it was. It is separated. Clause 8.
No, Chair.
Procedure, Chair.
Procedure, Madam. Chair, I differ from
Honorable Kabanda. It is separated. What we are going to do is on the what? when they are preparing the bill, they will correct that.
Chair, with due respect, I have understood. Honorable Semuju has moved that exhibiting
Honorable
videos.
Semuju separated the A, B, C, D.
Yes,
Proceed.
and he has suggested two different penalties. One 10 years and another 20 years. Yes, that's what he moved.
No. Life.
Procedure.
Procedure.
Madam Chair.
Honorable members, clause 8.
Procedure.
Clause 8.
Clause 8.
Right, Honorable, we've sold
Aiding
our
and abetting
children.
homosexuality. Delete clause 8. Justification. The provision is redundant since it is provided for under section 19 of the Penal Code Act, and the conduct intended to be cured can be dealt
Honorable
with
members,
under clause
order.
14
Santa.
on promotion. The provision uses words such as acts of homosexuality, which are ambiguous since they are not defined, thereby making the provision contrary to the principle of legality prescribed in Article 28(12) of the Constitution.
Nathan?
Thank you very much, Madam Chair. I'm not trying to differ too much from what the Chair is raising, but I wanted to ask a question. I don't know if Honorable Bart is around.
Honorable Bart is here.
When we passed this law in the 9th Parliament, there are colleagues of ours who went to court. They went to court. Anyway, it is Fox and Otada. And Madam Speaker, Madam Chair, having finished even the court, when we came here to pay tribute to the late Archbishop of Uganda, Ruum, one of the seconders was Fox, who was you said homosexuality, homosexual.
Procedure.
Madam
Procedure, Honorable Chair.
What's the procedure? When I'm here. So, Madam Chair, the issue I'm raising, this is the ones who aid and abetting homosexuality. Now, what about those who go to court? No, we don't want to delete it. That's why I want to bring
Honorable Nathan, you're taking our time.
Madam Chair, I want us to bring those who go to court, who yes.
Asuman?
No, Chair, I have no objection to the proposal by the committee.
Attorney General?
Just some clarification, Madam Chair. Madam Chair, because the justification for deleting, as mentioned by the chairperson here, is that there's no definition for acts of homosexuality. Why wouldn't we define such that's very clear?
We are going to define in the interpretation clause. That's clause 1.
Yeah, but because they are proposing to delete it and they are giving that as a reason. So, but if we are going to define,
They are
then
saying it
cannot
is
stand
a
as reason.
redundant clause. It
Okay,
is already
thank you.
provided for.
Clarification.
Attorney General?
Madam Chair, I have no objection.
I put a question that clause 8 be deleted as proposed. Those in favor say and the contrary nay. Let's have it.
Clause 9.
Clause 9.
Clause 9, conspiracy to engage in homosexuality. Delete clause 9, justification. The mischief intended to be cured by the clause can be dealt with under clause 14.
Atsman? Conspiracy?
Chair, I concede to the proposal.
AG?
I concede.
I put a question that clause 9 be deleted as proposed. Those in favor say and the contrary nay. Let's have it.
Clause 10.
Clause 10, procuring homosexuality by threat. Delete clause 10, justification. Consequential amendment arising from the amendment of clause 3 of the bill relating to the offense of aggravated homosexuality, wherein the clauses 1 and 2 of clause 10 were inserted in clause 3. Clause 10 conflicts with section 123 relating to the offense of rape and 129 relating to defilement by prescribing lesser sentences than those prescribed under the above provisions, affecting the provisions of the above acts. To remove a redundant subclause 10.2, which proposes to recognize a practice of court requiring corroboration.
Asman?
I concede.
AG?
I concede, Madam Chair.
Imat? I put a question that clause 10 be deleted as proposed. Those in favor said and the contrary, the ayes have it.
Clause 11.
11, Chair.
Clause 11, detention with intent to commit homosexuality. Delete clause 11, justification. Clause 11 is redundant.
Asman?
I concur.
AG?
I agree.
I put a question that clause 11 be deleted as proposed. Those in favor say on the contrary, nay. Let's have it.
Clause 12.
12.
Clause 12, brothels. Clause 12 of the bill is amended A, by renumbering the provisions as subclause 1 and 2. B, in subclause A by inserting the words